Medical records. As we've talked about on these video blogs before, lots of confidential information in your medical records. Things you don't want the whole world to see. Question: what happens if a court orders a medical examination, or if a medical examination needs to be done because of some litigation that's going forward? What happens to those medical records? Well, that brings us to this week's case. It involves a couple. They were involved in a divorce in Illinois. Well, it was second divorce for the woman, and there was a big question as to whether she was a suitable parent for custody of the children. The court, in order to make that determination of suitability, decided that she should have a psychiatric evaluation. So she went in for the psychiatric evaluation. It took place, and after it took place, her ex-husband, who probably was not the world's best friend at that point in time, began to tell the whole world about what the psychiatrist had to say. She sued him. She said, wait a second, I expected that medical exam to be confidential. And he's telling the whole world about it. He can't do that. I'm being damaged as a result of this. And it went to court. Went all the way up to the Illinois Supreme Court. What did the court do? Well, it took a look at this and it said, yes, medical records are confidential. But in this instance, what we're dealing with is not a therapeutic record. It wasn't a treating doctor. It was a doctor that saw her at the request of the court to make a determination as to whether or not she was mentally competent to look after the kids. And that was really information gathering by the court to make a decision. In that instance, she had really no expectation of privacy because she knew that the court was going to be using that to make a decision, and that decision was going to become a public decision, particularly as to what was going to happen on the custody of the children. Okay, so what's the lesson learned here? Well, the lesson learned here is pretty straightforward, and that is if you get involved in litigation and a medical examination is ordered, that medical examination may not necessarily be kept confidential. How can that happen? Maybe you're not somebody involved in a divorce, but maybe you're somebody that's had an accident. Maybe you're somebody with a disability claim, and you are going forward with a medical evaluation to determine how badly hurt you are, what the disability is. Can you anticipate confidentiality in that? No, you cannot always anticipate confidentiality in that. Is there something you can do to ensure confidentiality? Yes, there is. What can you do? You can require that the guys on the other side sign an agreement of confidentiality and that they are not going to release that information elsewhere. But that confidentiality agreement is only going to go so far. Let's talk about an injury case, been hurt in an automobile crash. Well, what happens when the guys on the other side have a doctor look at you that says you're not hurt all that bad? Are they going to make that public? Of course they're going to make that public. They're going to court. They're going to have that doctor testify. Going to be confidentiality there? No, there's not going to be confidentiality there. So you need to understand, while medical records are confidential, and there's lots of laws designed to protect them, there are instances that arise where they are not confidential. And you need to know what you can do to try and protect that confidentiality even when you're involved in a litigation process. Okay, we bring you this case as we bring you cases every week so you understand how the law works. I'm David Allen.